Hello everyone and welcome back to yet another video on financial laws. Now in the first video we have studied about SAR FAE SI Act 2002, wherein we have studied about its historical background, its object, its scope, its applicability, non-applicability and overview, right? So now in this video, in the continuation of the first unit, we'll understand various important terms associated with this law like securitization, asset reconstruction, security interest, non-performing assets, reconstruction company, then securitization company, appellate tribunal, borrower, banks, financial institutions, etc. Right? We'll also study the recovery of loans, the process of recovery of loans, and the mechanism behind the enforcement of this act. Okay, and of course the hierarchy of courts and all. So also find out loopholes, and we also study few cases. Okay, so let's begin with this video. You should prepare notes simultaneously, right? Now I'll share my screen with you all. Right. So in continuation with the last video, we understand the important terms associated with this particular act. The very first term is securitization, right? So let's understand what this term means. Now section 21Z of the SAR FAE SI Act 2002 states that securitization means acquisition of financial assets by any securitization company or reconstruction company from any originator, whether by raising of funds by such securitization company or reconstruction company from qualified institutional buyers by issue of security receipts representing undivided interest in such financial assets or otherwise. Like in simple words, it means that it is an innovation in the financial market which covers the process of converting the contractual debt into tangible securities and selling them to end investors after properly packaging and underwriting the same. So it is a process where an owner of receivables, that is the originator or the seller, sells off its receivable to a third party, the purchaser, in return for a purchase price payable immediately on sale. So securitization in its widest sense implies every such process which converts a financial relation into a transaction. Understood? Now, the next is asset reconstruction. Now, section 21B of SAR FAE SI Act 2002. It states asset reconstruction means acquisition by any securitization company or reconstruction company of any right or interest of any bank or financial institutions in any financial assistance for the purpose of realization of such financial assistance. So that is the meaning of asset reconstruction. The next, security interest. Now, section 21 ZF of SAR FAE SI Act 2002. It states security interest means right, title, and interest. Three things: right, title, and interest of any kind whatsoever upon property created in favor of any secure creditor, of course, and includes any mortgage, charge, hypothecation, assignment other than those specified in section 31. That is security interest. What is NPA? Now, section 210 of SAR FESI Act 2002 states, an NPA means an asset or account of a borrower which has been classified by a bank or financial institution as substandard, doubtful, or loss asset. We have studied about NPA a lot many times before. So, in such a case, in such a bank or financial institutions is administered or regulated by any authority or body established, constituted or appointed by any law for the time being in force in accordance with the direction or guidelines relating to asset classification issued by such authority or body. So in any other case, in accordance with the direction or guidelines relating to asset classification issued by the Reserve Bank, of course. We all know that there is a particular definition of non-performing assets, there is particular classification, right? The next is reconstruction company. Now, section 215 of SAR-FAESI Act 2002 states that reconstruction company means a company formed and registered under the Companies Act 1956 for the purpose of asset reconstruction. Simple. Now, what is securitization company? Section 21ZA of the SAR-FAESI Act 2002 states securitization company means any company formed and registered under Companies Act 1956 for the purpose of securitization. Simple. Now, what is appellate tribunal? Now, section 21A of SAR-FAESI Act 2002 states appellate tribunal means a debt recovery appellate tribunal established under section 8.1 of the Recovery of Debts Due to Bank and Financial Institutions Act 1990. And borrower. Who are the borrower? What is the meaning of borrower? Section 21F of SAR-FAESI Act 2002 states that borrower means any person who has been granted financial assistance by any bank or FIs and who has given any guarantee or created any mortgage or pledge as security for the financial assistance granted by any bank or financial institution, and includes a person who becomes borrower of a securitization company or reconstruction company consequent upon acquisition by it of any rights or interest of any bank or FIs in relation to such financial assistance. He will be called a borrower. Now, banks, according to this act, bank means a banking company or a corresponding new bank or State Bank of India, a subsidiary bank. Such other banks with the central government may be like by notification specified for the purpose of the act. And the last term, that is financial institutions, section 21M of this act states that a public financial institution within the meaning of section 4A of the Companies Act 1956 is called a financial institution. And any institution specified by central government under subclause 2 of the clause H of section 2 of Recovery of Debt Due to Bank and Financial Institution Act 1993. Third, the International Finance Corporation established under the International Finance Corporation, like Status, Immunities and Privileges Act 1958. And last, any other institution or non-banking financial company as defined in clause F of section 45 1 of the Reserve Bank of India Act 1934, which the central government may by notification specify as financial institution for the purpose of this act, can be considered as financial institution. So these are the important terms in this particular act of SAR-FAESI Act 2002. These are important for short notes. So these are very important points to be understood and learned. Okay. Next is we'll understand the process of recovery of loan with the help of these diagrams. Now the figure A. The figure A denotes the enforcement of security interest without intervention of court or tribunal. So how the process goes? The banks and FIs, the borrowers, you know who are the borrowers now? Loans due and classified as NPA if they are not able to pay. Then enforcement of the security interest under section 13 and auction sale and loans recovered. So there is no intervention of any court here. It is all done internally. Now in the figure B, we understand securitization and asset reconstruction. How it happens? Now banks and FIs give borrowers loans to the borrowers. Now these loans may be classified as NPAs if they defaulted. Now what happens? See the green one. Banks direct the securitization companies to take over the NPAs at a certain price, right? QIBs will invest in such scheme and company will issue security receipts to them. and securitization company devise a separate scheme for each financial asset taken over. So this is how the loans are recovered in case of securitization and asset reconstruction. Okay, so with the help of this diagram, in short, I have made you understand, but when you write it, you have to elaborate, right? And try to also define terms like borrowers and NPAs a little bit, so that you elaborate your answer. When you're writing a theoretical answer, you're writing a descriptive type of answer. Because in case of multiple choice questions, your concept should be very clear. Now, in the next diagram, we'll understand about mechanism behind enforcement of security interest section under section 13. So how the process is, let's understand with the help of a diagram. We'll start from the red point, default in repayment of debt or installment. Then banks and FIs classifies accounts as NPAs if they come under that particular area. The notice period of 60 days given to repay. Then representation or objection on part of borrower, if he has any, he can raise. And then secured creditor must give a reply to such representation within 7 days with reasons. If there is any objection from the borrower, then the creditor has to give any reply within 7 days. Then after expiry of the notice period given, debts are recovered in 4 ways. Now, how are the debts recovered in 4 ways? I'll tell you. Number one, take possession of the secured asset of the borrower, like including rights to transfer by way of lease or assignment or sale for realizing the secured assets, right? Number two, take over the management of the business of the borrower, including right to transfer by way of lease, assignment or sale for realizing the secured assets. Number three, appoint any person to manage the secured assets, the possession of which has been taken over by secured creditor. And last, number four, acquire at any time by notice in writing any person who has acquired any of such secured assets from the borrower and from whom any money is due or may become due to the borrower to pay the secured creditor so much of the money as sufficient to pay the secured debt. So these are the 4 ways recovery of secured debts is done, right? Now, this is an image of the possession notice. Now, important points to be kept in mind are that when a secured asset is immovable property and the borrower made a default, then after the notice period, possession notice is given under Rule 82 of Security Enforcement Interest Rules 2002, right? And virtue of Section 14 of the SER FAESI Act 2002, Chief Metropolitan Magistrate or district magistrate is to assist secured creditor in taking possession of secured assets. So these things have to be kept in mind when issuing a notice, right? So this is just a copy that I've shown you, a sample, an image of possession notice. Now has a hierarchy of the codes followed. This is how it is done. Now section 17 says any aggrieved borrower in relation to section 13.4 may take an application to DRT, that is Debt Recovery Tribunal, within 45 days from the date of measures taken, right? And the respective DRT must dispose of such grievance within 60 days from the date of application. And if application not addressed within 4 months, then he may apply to DRAT for expeditions dispose of the case. Now, normal appeal can also be made to DRAT within 30 days, the date of decision given by DRT. Only if 50% of the amount of debt claimed or determined by DRT, whichever is less, is deposited at first hand. That's the condition. Now, section 17 A says that in case of borrower residing in J&K, Jammu and Kashmir, application to be made to the court or district judge in that case. So this is how the hierarchy of courts is explained to you, right? Now there are certain loopholes in this particular law. Let's find out. Now, 3 things, that is asset reconstruction, securitization, and enforcement of security interest. At a single go slowed down the mechanism of the act on the number of occasions, right? So these were the loophole. Now, guidelines of the RBI in relation to classification of accounts as NPA are not followed strictly in numerous occasions. Also, the grievance of the borrowers are not settled at first place by DRTs. And also the sale of assets under Act sometimes conducted without following the rules and norms. And the last, to check out the loophole, maybe like civil courts very easily don't take cases related to SAR, FAE, SI Act. Without even looking into the facts of the case, this happens due to Section 34. So these are few loopholes in this particular act. Okay, now let's understand a few case law in the important judgments made in this particular under this particular law. Okay, let's understand. It's in front of you. You can just watch as I read. The Supreme Court in Madhya Chemicals Limited versus Union Bank of India case 2004 for SCC 311 has decided that the SAR FAESI Act has the constitution validity. Right? Number two, in case of Signal Apparels Private Limited versus Canara Bank, it was held that guidelines issued by RBI in relation to classifying NPA should be followed by the bank before issuing notice under the act. The loophole I told you, the guidelines are relating to NPA given by RBI was not followed. So here it was given. Third, in case of Ace Media Advertisers Private Limited versus Bank of Baroda, it was held that the process under Securitization Act can be confined to the extent of the decree order passed by Debts Recovery Tribunal, DRT. The hierarchy we followed, the lowest one in the hierarchy. Next, in case of Mahavir Plantations Private Limited and KK Steel Enterprises versus ICICI Bank and ORS, it was held that demand notice via Rule 3 of Security Interest Enforcement Rules 2002 to borrower under SAR FAESI Act is predatory. Proceedings without such notice will be vitiated. Right? Last, in case of Youth Development Cooperative Bank Limited Kolhapur versus Babasaheb Dinkara Saroke and ORS, it was held that civil court has no jurisdiction to entertain any suit filed in respect of action taken under SAR FAESI Act 2000. Right? These are few of the case laws. I've told you the real case laws, the real life examples, right? Which supports SAR FAESI Act 2002. Right? Now, a proper implementation of the sole securitization law in India should be ensured. It's very important. Now, DRTs must ensure effective redressal of the grievance of the borrowers. So the banks and FIs must follow the guidelines given by the RBI, especially regarding to the classification of NPAs. Now, look, the main intention of the Parliament behind enactment of this Act from an ordinance is to ensure proper recovery of bad debts without intervention of courts. But at the same time, they never want to ignore the grievance of the borrowers. Simply a balance between the two must be created. That is important. So, through the enactment of SAR FAESI Act, it sought to mobilize blocked funds of the banks in the non-performing assets. The various provisions of the acts have created deep sorrows for the genuine borrowers, actually. The various provisions meant to balance the requirements of the borrowers and the banks have their balance of favor titled towards the bank many times. So these powers are at majority of the times being misused by the banks to appropriate their interest against the interest of the buyer. So in such situation, it is pertinent for the civil courts to assume more social responsibility for the larger interests of the borrowers on one hand, and to share the responsibility of the bank to mobilize their funds and reduce NPAs, right? So this is all about your first unit, right? So now in the next class, we'll be covering your second unit. So before we begin the second unit, I want you all to prepare notes for your first unit and start studying, right? Because law needs a lot of study and practice, because there are a lot of laws, sections that you should by heart, right? See you in the next video. Till then, take care.